This is SJC-13252 in the matter of Roland F. Escobar Jr.
Okay, Attorney Lee.
Good morning.
Morning.
May it please the court, Mary Lee, Assistant District Attorney for the Bristol District for the Commonwealth. The issue before the court today is, it's a Commonwealth appeal, and it's whether manslaughter and assault and battery with a dangerous weapon causing serious bodily injury is within the umbrella of the pretrial detention statute in section 58A. And as we've seen, the language, it would be within the force clause from the Commonwealth's position. And as we've seen over the years, the force clause, which is identical to the definition of a violent crime in the Armed Career Criminal Statute, both of those statutes have had quite a bit of analysis regarding that language. And so the Commonwealth is stating in this appeal that the Superior Court judge, when the case came up for a bail appeal, made a clear error of law by finding that both of these crimes did not fit as predicate offenses under the dangerousness statute's force clause.
Mr. Can I ask you, does any court use a modified categorical analysis as opposed to an ACC situation for pretrial detention?
So with respect to the force clause, this court has not done that, but with respect to the abuse clause in section 58A, this court uses the modified categorical approach.
I thought the reason we did that was because there's no abuse language or no abuse crimes, right, per se.
Right.
So we're kind of stuck with that. But as far as the force clause is all over federal law, and from what I've seen is everybody uses. I've never seen modified categorical used in a detention statute, unless I'm wrong on that. Am I?
So the only case I'm relying on is Sion using, it called it a non-categorical approach on the abuse clause. And my position is, if this court can apply a non-categorical or modified categorical modified categorical approach within section 58A in any part of it, then of course you should be able to use it in this section as well. In the same way, the defendant is applying Dayton to use the rule of lenity. The rule of lenity has been applied in section 58A's clause on OUI 3, but not on the force statute. So I understand the court may be viewing my argument as a kind of in for a penny, in for a pound, but I think that's kind of a good description, because our first line of action here is that this fits within the categorical analysis, that the element of cause of death or causing serious bodily injury fits within the force clause. And our second line of argument is that if this court is applying Ashford, then you should, and you're going to import intent into the force clause in section 58A, then you have to use the modified categorical approach, because under Ashford, assault and battery with a dangerous weapon can fit within that exact same language for proof beyond a reasonable doubt, but it wouldn't be able to fit within section 58A's same language for pretrial detention. And that
on the force argument, I get what you're saying regarding voluntary manslaughter. I'm having trouble seeing your point on involuntary. And I think the point is made in the rare cases where a DA's office charges voluntary manslaughter, you could indict for voluntary manslaughter, correct?
Yes.
But involuntary, which involves like Wolanski, Levesque, in those types of cases, how do we get force in Levesque, for example?
So, I wanted to be very upfront with the court. I acknowledge Wolanski, Twitchell, and Carter in the involuntary manslaughter cases. And so our position is that you cannot cause someone's death without some infliction of physical force against them. People don't just die. And
if the homeless folks who were in the Worcester fire, unfortunately, they walk away and they don't call, how do they involve force to those firefighters?
And so it's an indirect use of force in those cases. And that's why if you're applying a modified categorical approach, you should be able to look at the facts. But I understand that is a harder argument, which I acknowledge in my brief, in terms of the indirect use of force with a manslaughter case, but they are still causing the death. You have to show causation in order to get the manslaughter.
I have no doubt that they caused the death. That's part of that's an element of proof. I'm just having trouble on the direct force.
Right, it's indirect, and
well, it's the use of I'm sorry, it's the use of force is the language. I think I might have stolen Judge Williams' question, but it's use of force, right?
Yes, it's use of physical force against the person of another. And
right. So how did Mr. Walensky use force against the people when he shut the doors?
So by ordering that the door be blocked, so when the fire incurred, he has done an intentional act, and that intentional act has as a natural and probable consequence caused force to be used against the people who died in that fire at the China Grove. So, and I understand that this is a separate course of events, but I would point to this court's decision that murder, which does not person is not entitled to bail under murder, but this court has found in the Vasquez case that murder falls within the within 58A, and murder can be done in the same manner, with not even being present, setting a course of action in place and creating the natural and probable consequences. And so I would suggest that the lesser included offense of manslaughter should fall within that as well. I would then move, so the Commonwealth's primary position is that both of these crimes, manslaughter and assault and battery with a dangerous weapon causing serious bodily injury, have the proof of cause of death or serious bodily injury, and that is the element of the use of force. So it's the use of physical force against the person of another. What the defendant and what the Superior Court judge ruled was that these were not predicate offenses, because she imported this court's Ashford case, which was in 2020, regarding the armed career criminal statute, into 58A and required the Commonwealth to show intentional conduct. And intentional conduct, I admit it's harder to show for manslaughter, which requires an intentional act but does not require malice. But I would suggest those, in the circumstance of ABDW SBI, it's assault and battery with a dangerous weapon causing serious bodily injury. If you look at the Ashford analysis, it wouldn't make any sense to have a modified categorical approach that permits ABDW on that same language to fall within the violent crime on the same definition, and then say, no, it can never be. And that is what the judge is saying here. ABDW can never be sufficient on that unless the Commonwealth alleges intent and forgoes any reckless theory. We don't even have to forego a reckless theory for armed career criminal. We can go under both theories, and the jury gets to decide what is proven beyond a reasonable doubt. And so,
isn't that the key, that there's a jury involved in that? I mean, here you're detaining people pre-trial, they're presumed innocent, you have none of those procedural safeguards that you have for the jury trial, and the default is you don't detain people. And isn't that why we're not normally applying the modified categorical approach?
I disagree. I think that this is on a probable cause level. The ABDW fits more cleanly into the pretrial detention statute, because it has a use of force, which this court has found can be proven through intentional acts. And so the Commonwealth should not be foreclosed by simply because it says we can also prove it by reckless. And so we should be able to use a modified categorical approach. We have the elements, we have a theory of intent, and we should fit within categorical approach. And if we don't, Ashford, if you're going to apply Ashford and its requirement of intent, then you should let us show our facts. We never got our hearing on the facts because the judge ruled as a matter of law, ABDW causing serious bodily injury, and therefore ABDW generally, can't be within 58A at all. And that can't be what the legislature requires. Like if you go and shoot somebody, I'm sorry.
Well, you could have indicted, when it went to Superior Court, if it was an intentional act, you could have sought an indictment for intentional ABDW, serious bodily injury, correct?
So what you'd be requiring the Commonwealth to do is to actually get 2 indictments then and move on the pretrial detention for one and not the other. And that doesn't make any sense either.
I thought it was a district court. I thought you asked for detention in Superior Court, right? So when you knew it was an issue, you could have indicted for intentional ABDW, right?
We could have done both, but I don't think the law requires that. And it doesn't make sense to have 2 charges against the defendant for one case. I mean, for one incident, that's also not fair to the defendant to have 2 ABDWs, one for the pretrial detention and one to make sure we can prove our reckless theory at trial if the jury doesn't find intentional conduct. And that's why the modified categorical approach makes, so then the judge can make the probable cause finding on the crime and then can look at the facts of the case to determine whether we fall within the clear and convincing evidence of dangerousness, which the Commonwealth maintains our evidence would show that, and we never even got there. This statute is to protect the public. It's to protect from future irreparable harm. And it's to doing so in a way that protects the defendant's rights. ABDW and manslaughter are crimes of force against the person of another. And if you import Ashford with its intentional element into something that is shown at probable cause level on the day of arraignment, in most cases, I realize this case has been extended out, but on the day of arraignment by probable cause, you have to let us use the modified categorical approach when there are 2 theories. When we walked into court on the day of arraignment in district court, we shouldn't have to say, oh, we're always going to just require intent and we're going to give up recklessness forever just to fall within the pretrial detention statute. That cannot be what the legislature intended when they talked about the use of force against an individual. I'm happy to answer any other questions.
Sure. Well, I have a question, but it's more conceptual and not so much in the details of the statute. And is that when you look at the statute, you know what the legislature was trying to get to in terms of pretrial detention to keep people safer. I'm not sure that they had in their imagination a car accident, or even if it's a reckless car accident. It's just as a matter of what did the legislature intend broadly for this statute, not what we've decided on specific issues, but how does it work? How does that work? And where does it end?
So the legislature's intent is, it's a kind of a tortured analysis here, because obviously they had the now unconstitutional residual clause where crimes that you were discussing would naturally fall into. And there are also lesser crimes that are specifically categorized. And I realize this court has also called out to the legislature, like, if you disagree with us, I believe it was on the sexual assaults, you can amend it. And that has not been done. But I would suggest in this circumstance, with an ABDW causing serious bodily injury and where a person has died by manslaughter, that this is not a car accident. This is a collision. And the evidence here on the modified categorical approach would show it was intentional, because there was a car struck, then he drove around the car that was struck, then he committed the fatal infliction of injury, physical injury on the woman who was just getting into her car after buying shoes. And then he went on to hit several more cars before the rollover.
Ms. Lee, isn't the problem here that we're not just interpreting 58A in a vacuum here, that we're interpreting it with the residual clause being held unconstitutional. So we're not looking at the whole statute as passed, we're looking at the fourth clause. And when the fourth clause was written, the legislature recognized that there was a residual.
Yeah, I understand that the legislative purpose originally would have totally included this case. And I would suggest to the court that this case still falls within it, so the legislature would not have seen a need to amend it. And I also rely on the analysis in the Borden case from the US Supreme Court. Thank you.
Okay, thank you. Attorney Levin.
Thank you, Your Honor. Good morning. May it please the court, Patrick Levin on behalf of Roland Escobar. There's sort of two pieces of this case, and both of them are controlled by this court's prior cases. So the first part is whether the modified categorical approach can apply in a pretrial detention setting. And then the second part is whether the force clause encompasses crimes that can be committed through a reckless causation of injury. Speaking first to the categorical approach, the 58A process works in two steps. The first step is that the judge at arraignment looks at the face of the complaint, looks at what the charges are, and does a legal analysis of the elements of those crimes to decide if they match up with the predicate offenses that are listed in 58A subsection 1. And the second stage, the actual dangerousness hearing, is the only part where the underlying facts as alleged are to be considered by the judge. It's very clear in this court's cases, in Young and in Sioni and then again in Vieira. And footnote 14 of Vieira in particular speaks directly to this. Specifically says, at a bail determination hearing, we do not look beyond the elements of assault and battery to discern on a case-by-case basis whether a harmful, reckless, or offensive battery.
Mr. Levin, let me ask you about the modified categorical.
Yes, Your Honor.
Has that been used in any detention statutes?
No, not that I'm aware of.
Other than what we did in abuse, as Ms. Lee points out. But
So-
has it, because there's lots of force clauses in the federal statute and other states. Has modified categorical been used?
I haven't done an extensive, 50-state survey. To the best of my knowledge, the federal courts have uniformly followed the analysis of the District of Columbia Circuit in Singleton, which was the case this court relied on in Young, which requires a categorical approach to be applied under the Federal Bail Reform Act. Speaking specifically to the abuse clause and this court's analysis in Sioni, I would disagree that that is a modified categorical approach. The thing about the abuse clause is that Chapter 276, Section 56A requires at every arraignment the judge to make a finding of whether abuse is alleged or not in connection with the crime. And the Commonwealth has to file a written statement along with the complaint if abuse is alleged. So at every single arraignment, that question of is abuse alleged in connection with this offense is in front of the trial judge without them actually having to look underneath into what the specific factual allegations of the crime are. So there is no inquiry into the facts of a particular case, even in the context of the abuse clause. It's just whether the Commonwealth has filed that statement that abuse is alleged.
So the next question, Mr. Levin, is if not, why not? Why not use modified categorical in the detention situation when we did it in Ashford and basically follow Supreme Court case law, as it turns out?
Yeah, so the first reason is that the statutory language is pretty clear in terms of speaking about what are the elements of the offense as charged. And so if on the face of the complaint, you can't see that at trial, the jury is going to have to find a use of force against the person of another unanimously beyond a reasonable doubt, then that's not an element of the offense as charged in the complaint. The second reason is that this is an arraignment, and these things need to move. The judge can't be making factual determinations about the facts of each individual case at arraignment. And that's particularly true, I think, in the superior courts, where I guess you would have to have the judge going back through the grand jury minutes at arraignment and trying to figure out what the basis of the crime is. And then, of course, the other thing is that in a lot of cases, speaking to assault and battery, for example, a given factual allegation could support either version. It could be a reckless causation of injury, or it could be an intentional act. And it's up to the jury to decide ultimately. But it's not always going to be clear whether an intentional use of force is alleged at all.
Mr. Levin, can I ask you a question about that? Why couldn't you do that on the face of the complaint? I mean, there were two-wit clauses all the time, right, where they allege the general law that's been violated, and there's a little paragraph on the complaint that has just enough of the factual background from the application that could say what Attorney Lee said the first time, by swerving around the vehicle after the initial accident. There could be something kind of akin to a two-wit in the complaint, that it wouldn't involve a whole lot of work by the presiding judge at arraignment to determine that, the if not, why not?
Well, Your Honor, I'm not going to say that you couldn't allege some of the facts of the case on the face of the complaint. Usually they don't. In this case, it doesn't. Usually the complaint just tracks the statutory language. But so if you look at the structure of the pretrial detention statute, right, it's pretty clear. Like, you have 58A subsection 1. These are the predicate offenses. What are the elements of the offense? The residual clause says other offenses which by its nature presents a substantial risk of force. And then if you look down to the subsection that deals with the actual dangerousness hearing, you have this direction for the judge to consider, based on the nature and circumstances of the offense, whether any conditions of release can suffice to protect the public. And what the DC Circuit says in Singleton and what this court says in Young is that you can tell that from that disjuncture, the nature of the offense has to do with the legal elements of the offense as a formal matter, and then the circumstances of the offense have to do with the offense as alleged in a particular case. And so the nature of the offense is relevant at the arraignment, and then the circumstances of the offense only become relevant at the actual dangerousness hearing. And what this court's holding was in Young is that any inquiry into the underlying allegations collapses that distinction improperly. The legislative intent is for this to be a legal analysis at arraignment. And it's also important for that list to have specificity for due process purposes. The only reason this statute is constitutional in the first place is because the predicate offenses are strictly limited to a specified list, categories of offenses that can be determined ahead of time. And so if you need to inquire into the allegations of an individual case in order to figure out whether it falls into the pretrial detention statute in the first place, you're back in the world that the predecessor statute had, in which was struck down partially for that reason in AIM. If there are no more questions on the categorical approach, I would move to this question of whether reckless conduct qualifies. Just to say that the language obviously is identical between this statute and the ACC, and there's no reason why it would mean anything different in Section 58A than it does in the other statutes where this force clause is used. That's particularly true where you can see that if the legislature wanted some other kind of crime to qualify under Section 58A, they just appended that crime to the list of predicate offenses. And so you have, this list that says you get the force clause, the residual clause, burglary and arson, and then, restraining order violations, certain drug offenses, certain gun offenses. If the legislature wanted some other crime to qualify that didn't fall within the language that was previously used in other statutes, it didn't secretly use the same language to mean something different in this statute. It just added those other offenses to the list. And so it's very clear from the federal cases and from this court's analysis in Ashford, a use of physical force against the person of another requires that the force be consciously directed at that person. And a crime of recklessness doesn't require that. So reckless crimes don't qualify as a crime whose elements require a use of physical force against the person of another. Just to briefly address the Commonwealth's concern about having multiple indictments related to the same charge in order to qualify for pretrial detention, I certainly am sympathetic to the idea that it's not fair to a defendant for the prosecutor to charge multiple crimes arising out of the same incident, but that has not historically been the view of the courts or of the Commonwealth. And in this case, you can see the assault and battery charge is based on identical conduct against an identical victim as the manslaughter charge, and the serious bodily injury that was alleged is the death of that victim. So there doesn't seem to be any practice of only charging, the minimum amount of charges that would capture the conduct that's alleged. So certainly the Commonwealth could charge various different crimes and try and choose one that does qualify for pretrial detention if that's one of their concerns. In terms of the legislative intent, the court already has discussed the residual clause, which was the way that the legislature tried to, bring some other crimes that didn't strictly require force as an element into this statute, which obviously has been struck down. Just in terms of whether the legislature contemplated a car accident as a potential predicate for detention, I do think it's important to note the inclusion of OUI third on the list of predicate offenses, which does seem to show some legislative consideration of the point at which driving offenses begin to rise to the level of dangerousness that should qualify them under this statute. And so if it, and that's what the court in Young sort of calls that out as well and says, look, the legislature clearly has thought about at what point do driving offenses rise to this same level of dangerousness, and that's where they set that line. And so I do think you do see some legislative contemplation of driving offenses possibly being included, but they're not the offenses that are charged here. If there are no more questions from the court, I would like to reiterate the request I made in my brief for the court to issue an immediate interim order for a bail hearing in the Superior Court with an opinion to follow. Mr. Escobar has been held now on these charges for 9 months unconstitutionally. And other than that, I would rest on the brief.